Hello and welcome to Case Closed. I'm Tracy Perry, your host. We'll soon go inside an actual courtroom in the Warren District Court to see real small claims cases in action. Now, under Michigan law, small claims cases may be brought by individuals seeking $3,000 in damages or less. Neither side may be represented by an attorney in small claims court, and the judge's decision is final. Now for the case of traffic turmoil.
Mr. Morogi, this is your case. Tell me what is going on with this case.
Well, basically, she's responsible for a car accident. She was getting out of a car station and gas station, and she made a left turn into the center lane, and then just as I was driving out of the blue, she just came out in front of me and hit me. So this is the photo that I took.
Now let's take a look. Did she ever get a ticket?
I don't know.
No, sir.
So basically, I brought the insurance papers and the police report. It clearly shows that it's her fault, and she does specifically state that I hit him. So it is her fault, and I had to pay insurance, $1,000 deductible.
Why are you suing for $1,500? Aren't you suing for $1,500?
Well, for damages to my car, and that's not the whole thing. It's just I borrowed money from credit card of my brother, and there's interest on that credit card. So
Why did you borrow money? For what?
how am I gonna pay for the insurance? So they fixed the car.
Wait a minute. Did you have insurance or not?
I did.
Did the insurance pay for the damage to the car?
They fixed it, but I had to pay deductible,
$1,000.
$1,000.
Okay. Then that's what you're entitled to, if anything.
Yeah, but for the credit card that I borrowed money from my brother,
$500 in interest?
well, it's been 1 year almost since that.
No, you're not, Mr. Morogi, you're not getting that. Okay.
Okay,
At most $1,000.
but it's not my fault.
What?
It's not my
Well,
fault.
whose fault is it that you,
Happened.
well, whose fault is it that you had to borrow money on your credit card? It's not her fault, is it?
Well, I didn't have the money.
Well, that's not her fault, is it? Right? If anything, it's her fault up to $1,000 maybe, depending on what happened here. But it's not her fault that you didn't have enough money to pay for the rest of this and had to get a cash advance on a credit card. Right? Which way were you going? Were you at 12 Mile or not?
Yeah, I was going west on 12 Mile,
Okay.
and she came on the center lane, and then I was just driving, and she hit me, and I was able to make a little bit of a right turn to go to the other lane, but I still got hit, and the door got smashed.
Finding out who is at fault in a traffic accident can be a tricky situation. The plaintiff clearly is placing all the blame on the defendant, which is what most people would do. Let's see what the defendant has to say.
Ma'am, what's your version of the story of the accident? What happened?
I was coming out of the gas station, and I asked the lady if I could go, and she said go. So I went, and he was coming. He was speeding, because it says right there in the report he was coming, and then he changed lanes. So like we both collided.
I was not speeding. It said there in the police report, I hit him, she hit me. It says there specifically, and she signed that on the police report.
Well, she says that she hit you, but she also basically says that she hit you because you changed lanes. That's
I was going, and when she hit me, I changed lanes.
That's not what she wrote, okay? I mean, I'm
Well,
not
that's what
necessarily
I-
saying that she's not at fault, but you're mischaracterizing what she said. If you read what she said that she hit you because you changed lanes. That's really what she's saying. You didn't tell me the whole thing.
All I know was that I was going and somebody hit me.
Well, I understand that.
I tried to
What
direct.
I'm telling you is what you're telling me is not what she wrote, okay?
Okay.
You're taking it out of context.
It looks like the defendant didn't have to say much. Between her testimony and the police report, it seems to indicate that both drivers share some of the responsibility. Let's see what the judge decides.
You know, I cannot tell whose fault it is. And when I read the statements here and I listen to the two of you, it's arguably you shouldn't have made the turn. Arguably you shouldn't have changed the lane. There's no way to tell. And I suspect that's why the police didn't issue a ticket, because the officer who wrote the report probably couldn't tell either.
She was saying that she was sorry and all that on that
Well, maybe
day.
she was sorry.
Well,
I'm sure
it's
she
her
was
fault,
sorry.
though.
What?
It's her fault, though.
Well, that's what you think. She probably doesn't think so. Do you think it was your fault?
No, sir.
Ah, well, look at that. You
Because
say it's her
there
fault.
was-
She says it's not her fault. Gee, what do I do?
It says on the report, it says she hit me, and
We've been through
Her
that,
fault.
okay? Yes, she hit you, but that doesn't necessarily mean she's at fault. Okay, maybe you hit her. I can't tell who is at fault, okay? I can't tell if, as I said, I can't tell if you changed lanes improperly, and I can't tell if you made the turn improperly. There's no way from what the two of you are telling me here today, and there's no way after looking at the police reports and the two statements that I can tell that. It's one of these things where you had to have been there to see. And as I said, I think that's why the officer didn't write a ticket, because the officer couldn't make that determination after investigating. You have the burden of proof, sir, because you're the plaintiff, so you have to prove the case, and if you don't prove the case, then you lose. And because I can't tell, it means you didn't prove the case. Maybe she was at fault, but I can't tell based upon what's happening here in court. And if I can't tell, as I said, you lose, so the case is dismissed.
Thank you, Your Honor.
You're welcome.
Well, without a clear understanding of who was at fault in the accident, the judge really didn't have much of a decision but to dismiss the case. Now we'll take a look at the case of the dirty apartment.
Ms. Breckner, this is your case. Go ahead.
Okay. Your Honor, the defendants rented an apartment from us. They moved in January 1st, 2010. They signed a 6-month lease, which thereafter went month-to-month tenancy. They moved out December 10th, 2011, returning their keys that day. Their lease requires that they give a written 30-day calendar month notice. They gave notice on December 3rd to move January 1st. We are asking for December's rent and for damages to the carpet. They had a new carpet when they moved in, and it was badly stained when they moved out and had to be replaced.
Okay, you have a lease with you?
Yes, sir.
Can I see that, please? Now, you're suing for $923. Is that after you deduct for the security deposit or not?
Yes, sir. $100 security deposit was deducted.
So then $923 is left, correct?
Correct.
You've given me a lease that was signed apparently on December 30th, 2009. And it was to begin New Year's Day, New Year's Day 2010.
Yes, sir.
For 6 months, as you indicated, and then it was month to month thereafter. Rent is $580, correct?
Correct.
Okay. And where is the paragraph that deals with ending the
Paragraph
lease?
27.
Paragraph 27. Notices. It is mutually agreed that a calendar month's notice and a 30-day notice are equivalent terms. Okay? In all calendar months and 30 days notices between landlord and tenant, A must be in writing, B must be received on or before the first day of the calendar month they cover, and C shall not be effective until the last day of the calendar month they cover, notwithstanding any language in the notice claiming an effective date prior to the last day. Any notices between landlord and tenant other than those relating to the security deposit shall be deemed as sufficient notice and service thereof if the said notice to the tenant is in writing, addressed to the last known post office addressed to the tenant, or addressed to the tenant at the apartment under this lease and deposited in the mail. And notice to the landlord shall be deemed sufficient notice and service thereof if the notice is in writing, addressed to the landlord's last known post office address and deposited in the mail. Notice agreed to be sent to only the one tenant and landlord, where the tenant or landlord consists of more than one person. A notice sent by U.S. mail shall be presumed received on the next regular day for mail delivery after the day when it was mailed. All right, now, you're saying that the defendants gave a notice that they intended to end the lease on what day, ma'am? December?
January 1st, 2012. I have a copy of their notice if you'd like to see it.
Yes, I would like to see that. All right, this is a 30-day notice of intent to vacate. It says, as tenants, we understand it is our responsibility to give a written 30-day calendar month notice to Gordon Bagan Properties for our intent to move. If notice is given during the term of our lease, we realize we are responsible for rent until the apartment is re-rented or the lease expires, and we have given the proper 30-day notice. Well, we don't have that here. This is a month-to-month lease. Notice is due on or before the first day of the month. Example, July 1st, 2000, to move out on or before the last day of the month. Example, July 31st, 2000. If notice is given any time after the 1st, we realize we may be responsible for rent through the end of the 30th of the next month. Our move-out date is recorded as the day we return our keys. And this says we intend to move out of the of this apartment January 1st, 2012. And this is dated December 3rd, 2011. Signed by Marion Mitchell. And the reason is we are expecting a newborn and we need a place with at least 2 to 3 bedrooms. Very good. So you're asking for rent for the month of December, is that correct?
We're asking for rent for the month of December. They did have a rent increase, which went in effect July 1st of 2011
Okay,
to $600
so you're asking for that amount.
and a late charge of $60.
And a late charge of $60, that's $660. And then you have the carpet cleaning fee?
Then we have a carpet replacement.
Replacement.
Yeah, the
What about that?
carpet was prorated. The courts have given us a life expectancy of 5 years on the carpet. And this carpet, we charged them $363. We have a bill here for $899 for carpet and tile.
Let me see what you have. What was wrong with the carpet?
It was very badly stained. Here's a work order when they went through the apartment of what was done, what needed to be done in the apartment.
What's this document in printing that you gave me here? Printing by hand. Kitchen says
That's-
countertops, refrigerator, what's that?
That's when our manager went through and inspected the apartment. That's what needed to be done
After the tenants left, right?
after the tenants moved out,
It
yes.
says carpet, very stained, replaced. How old is that carpet?
That carpet was put in a couple months before they moved in, October of 2009, and they moved in January 1st, 2010.
You've given me an invoice from SCI Floor Covering Incorporated, dated December 30th of last year.
Yes, they moved out December 10th of 2011, and the carpet had to be replaced.
Cost is $899.67.
That was for carpet and tile. We did not charge them for the new tile because the tile was more than 5 years old. The tile was previously put in April of '04.
How much of the carpet portion of this are you charging the defendants?
The,
I'm sorry?
I'd have to see the form there to add it up.
Take a look.
Sorry, sir.
That's all right. You've also given me a letter to the defendants dated May 18, 2011, which reads as follows. Due to the increased cost of maintenance, taxes, utilities, and insurance over the past several years, we are forced to increase your rent at this time. Please choose one of the following options. 1, if you would like to continue as a month-to-month tenant effective July 1st, 2011, your rent increased to $600 per month. Your rent will increase to $600 per month, and your late charge will be $60 per month. I guess that's what we have here. 2, if you would like to sign a new one-year lease with us, your rent will only increase to $590 per month as of July 1st, 2011, and your late charge will be $59 per month, $1 less. You will need to contact your rental office. There's a number, and fill out a lease renewal application prior to June 15, 2011. Reminder to all tenants, all the regulations, terms, and conditions as set forth in your lease agreement, including the requirement of a written calendar month's notice of intent to vacate, will pertain to your tenancy. We are pleased that you have chosen our complex as your home. Sincerely, Gordon Bagan Properties. All right, so this is option number 1 that the defendants chose. You figured that out?
Yes, $539.97.
So you're charging $539.97 of this.
No,
The carpet cost was $539.97.
And we prorated it for normal wear and tear and charged them $363.
$363. Now, how did you come up with that?
We divide it by 60 months and multiply it by the months left on the carpet.
Months left on the life of the carpet, you
Yes,
mean?
sir. Yes.
But it was a new carpet, wasn't it, that you had?
It was a new carpet when they moved in, but we don't charge for normal wear and tear. So we give them credit towards a portion of the carpet.
So this was the portion of the replacement cost of the carpet that was not attributable to wear and tear? I think is what you're saying? You're not charging them the cost of the full new carpet.
Right. That's what I'm saying.
And the reason why is because they shouldn't have to pay for a new full carpet because the fact that they had to, the fact that you had to get a new carpet, some of that was because of normal wear and tear, not because of them just ruining a brand new carpet necessarily, but part of the reason it was replaced because of wear and tear.
Right.
And that's
Yes.
that's where the credit comes in.
Yes, yes. So like 200 of it was normal wear and tear, and 360 of it was for their staining the carpet.
Okay. But you're suing for $923. This is more than $923 if I add 363 to 660. It's $1,023, I think, isn't it?
Yes, minus $100 security deposit.
Ah.
Sounds like the apartment complex is suing for some back rent and then damaged carpet after the defendant moved out. But they've also deducted the cost of the replacement carpet due to normal wear and tear, which sounds extremely fair. Let's see what the defendant has to say.
Mr. Mitchell?
Yes, we was expecting a new child, December 6th, scheduled C-section. So prior to that, we had started looking for a new place. Originally, we were going to try to get a 2-bedroom at Harlow Apartments. But, you know, we had certain problems with their management, and we decided we didn't want to stay there. We actually felt like we wasn't wanted there. So we decided to start looking for a house. And for about 3 months, we was looking for a house, and we absolutely wanted to make sure we gave them the correct 30-day notice. And, you know, we had so many different problems. And then our agent called us on the 2nd of December with an offer for one of the houses that we seen. And, of course, we accepted, which is a day later than what our 30-day notice was supposed to be. So I originally, after talking with my agent, I wrote out a letter. I called Gordon Began's office and spoke with the person who handles the Harlow Apartments. I didn't receive an answer. I left a message, and I put this letter in their mailbox, the same mailbox I pay my rent every month. This was a Friday. Saturday morning, I got up about maybe, I went to the office about 9 o'clock and spoke with, I think her name was Luann, and I explained my situation to her, that was December 3rd. I explained my situation, and she said, well, you need to have a 30-day notice form, which is the same form she gave you, I have here. And I explained to her that, you know, we just didn't want to bring our newborn home to, you know, such a cramped situation. When we originally moved in there, we had a 1-year-old daughter, which they knew. And, you know, at that point, my daughter had to sleep on the floor because of, you know, 1 bedroom. So we just didn't want to bring 2 children into that situation. So we, when this house was presented to us, we originally gave them the 30-day notice. And then the next day, my agent called and said the landlord of the home, he wants us, he said it's another family looking to get in the house, and they can't allow 30 days before we move in. So if we want the house, we have to take immediate occupancy. Okay, so you know, that kind of put us in a bad situation, but I felt we had to make the decision to go ahead and move immediately for the sake of our children. And I actually moved out all our furniture on December 6th, the same day my daughter was born. And, you know, the next few days from that, I was going over there, cleaning up anything that was, you know, like papers or whatever left over, throwing them away. And I swept and vacuumed the rug. And yes, the rug had, you know, some little stains. My daughter may have spilled some Kool-Aid or something on
How old's your daughter at the time?
Now, at the time, 3.
Okay.
She's still 3 now. Her birthday is August 6th. Okay, and you know, we wanted to get the carpet shampooed, but I didn't have the extra money to rent a shampooer or whatever. But all the carpet needed was a good shampooing. The carpet wasn't ruined. You know, I mean, I'm sure you had children spill pop or something on the carpet. That don't mean you have to pull it up and replace it because a couple of stains was on it. We just never had the time, didn't get around to doing the shampoo. We understand that maybe, you know, we may owe for shampooing or whatever, but
Shampooing the carpet.
yes. So on the day that she said December 10th, after I cleaned up everything, got it spick and span as clean as I could, I took pictures. Unfortunately, we don't have pictures because they're still in our digital camera and they said we couldn't bring it in. But I went to the office to turn in the keys, and I explained to the lady that, you know, we had to move out immediately because we was going to lose the home if we didn't move out immediately. And we understand that we owe you for the month of December. But I know I don't have it at the moment because I had to use that money towards the security deposit on the other home. And I explained to her that I definitely will pay the money for the December rent. I just won't have it until like January or February. I honestly was waiting for my income tax check so that I have the extra money to pay, but I owed taxes and they took my check. And that's the reason why at this date I hadn't paid the rent yet.
Do you dispute that you owe the $600?
No, I don't dispute that I owe the $660.
$660,
Yes,
right.
I admit that I owe the $660, but the replacement of the carpet I don't agree with at all because the carpet just needed shampooing.
Well, what about that, man? Can't you just shampoo that carpet and clean it up? It doesn't seem like it's that big of a deal.
Well, the stains don't come up. Kool-Aid, wine, paint. I mean, I've had kids too, and I know.
So have I.
And we just can't re-rent the apartment if the carpet is stained. People don't want a stained carpet.
So the defendants concede that there was some damage to the carpet, but they feel like those stains would come out with a good shampooing. Let's see what the judge has to say.
Well, first of all, you owe the $660.
Yes.
So that part of this I'm not even going to get into because you admit that you owe that, and I think you do. Let's talk about the carpet. You know, you're not required to pay normal wear and tear, or you're not to pay. Let me rephrase that. You're not required to pay the costs associated with fixing items in property that you rent if the problems of the items result from normal wear and tear. That's just part of the cost that a landlord has to bear. If it goes beyond that, then you are required to pay for it. The question in this case is whether or not the stains on the carpet consist of normal wear and tear. And it's a little hard to decide because we don't have any pictures of the carpet. You admit that there are some stains on the carpet, so there's no dispute that something needed to be done to the carpet, and you also wanted to shampoo the carpet, clean the carpet. So at least in your mind, there was something wrong with the carpet in terms that it had to be cleaned. We don't know whether, I guess, shampooing the carpet would have actually worked or not, because that wasn't tried, it was just replaced. But I'm inclined to believe the testimony of the plaintiff regarding the carpet because you're admitting, Mr. Mitchell, that the carpet already was in some sort of condition that required at least cleaning or something to be done with it. You're not telling the court that the carpet was in good condition. Something had to be done. I think it is a valid point made by Ms. Breckner that when you rent property, when people move into the property, they expect the carpet to be clean and to be without stains. That's part of what people want when they move in. So you can't just clean a carpet necessarily and say that the problem is taken care of. If those stains would have been only partly removed, I guess we don't know that, but if they would have been only partly removed, that would have been good enough, because people are entitled, as I said, to move into property with no stains on the carpet. It's hard to get people to move into properties that have stains on the carpet because you don't know where they come from. And in this instance, the question is whether or not the plaintiff acted reasonably in just replacing the carpet as opposed to attempting to shampoo it. Even if they attempted to shampoo it or clean it or do whatever you want to call to it, you still would have been responsible to pay for that cost, the cost of cleaning. And you're not even disputing that. You're just disputing whether or not you should pay part of the replacement cost of the carpet. The plaintiff made a decision, I guess an executive decision, that cleaning the carpet wasn't going to work. It had to be replaced. On balance, I find that that was a reasonable thing to do, given the fact that they didn't want stains in the carpet at all and shouldn't have to rent the property with stains in the carpet at all. So replacing it would have been reasonable, I think, based upon what I know. They're not charging you for the full cost of that, and who knows, by the time we actually compare the cost of your portion of a new carpet with cleaning it, might be pretty close anyway. Might not be that much, might not be that far apart. So I'm going to allow the cost of, or the partial cost of replacing the carpet in plaintiff's claim, and will enter a judgment in favor of the plaintiff in this case in the amount of $923. The court will add to that cost, consisting of a $45 filing fee and a $52 service fee, bringing the total amount of the judgment, I believe, to $1,016. No, $1,020, I'm sorry. And that will conclude the hearing. Have a good day.
Judgment for the plaintiff. You really have to be cautious when moving into and out of a rental property. Document every problem when you move in and clean up any stains when you move out, or you'll end up paying in the end. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Tracy Perry.